All right, we have a pretty packed agenda in our 2.5 hours together, so I am going to go ahead and get us started. First of all, I want to thank everyone for joining us today for our Asylum Pride training. We're thrilled to be meeting with you all and talking about what it means to take on an LGBTQ asylum case with NIJC. By way of introduction, my name is Charlotte Saul. I use she, her pronouns, and I'm NIJC's pro bono manager. So I work to connect pro bono attorneys in our network to various opportunities. One of the main ones is taking on an asylum case for full scope representation. A few logistics to get out of the way before we get started. There's a Q&A feature in Zoom. You'll see it at the bottom of your screen. You might have to click the More button with the triple dots, and then you'll see Q&A. That's the best way to submit kind of any questions about the content of this training so that any of us can answer them, and then the answers will be published for everyone to see. You also could use the chat in the right sidebar of your screen, but it's a little harder for us to monitor the chat throughout, so we gently encourage you to try to use the Q&A feature at the bottom of the screen. Also, we do offer CLE credit for attending this presentation for anyone who's attending it live right now, so not for the recording. There will be 2 CLE codes throughout the presentation, meted out throughout the time together. You need to listen for those codes and you need to write them down. Tomorrow, we'll send a follow-up email to everyone who registered, and that email will have a survey. You must fill out that survey to request CLE credit. And in the survey, you'll have to list those 2 codes that you were provided. So we really recommend listening for the code. We'll try to be really clear when we're giving them and making sure you write it down so that you remember it tomorrow when you have to submit that survey. Okay, now that the logistics are out of the way, if this is your first asylum training with NIJC, welcome. And if you've previously worked with us on an asylum case or any other type of case, welcome back. We're happy to have you. I just want to start by setting some context. Obviously, I think many of you know this, but we are in a historic moment where we're seeing our asylum system under attack, and where we know that access to a lawyer is one of the best tools that we have to help people navigate what is a really grueling, bureaucratic, difficult, unfair system. And increasingly, our asylum clients are facing really challenging hurdles, even just to get to the starting line of presenting their asylum case. For example, threats of detention that really change the course of their asylum case. So we want to make clear that taking on an asylum case for representation often means significant advocacy even before that starting line and also throughout the course of the case. We're going to go through the nuts and bolts of the legal basis for asylum, how to work with an LGBTQ person, all of those things today. And you would always have someone from NIJC who is supporting you and providing technical assistance on your case. But we just want to be clear, and I think you all know this is not an easy pro bono thing to take on. It really requires you to be dedicated, committed, and to be walking through every step of the process with your client. And we hope some of you will leave today and say that you're ready to do that, and that we will be able to support you in taking that on. So with that, just the brief goals for today. We're going to go through the basics of taking an asylum case with NIJC. We're going to focus on defensive cases. We'll talk about the difference between defensive and affirmative asylum. We'll also hope that you will gain these fundamental skills for working with asylum seekers, like client-facing skills, working with interpreters, that sort of thing. You'll also hear about NIJC's specific model of how we place pro bono asylum matters, and then understand the nuts and bolts of next steps should you be interested in taking on a case. Here's the brief agenda for today. I'm not going to go through it in detail. There will be 2 breaks. There will be 2 CLE words, and you'll get to hear from my wonderful colleagues who are joining me here. They will each introduce themselves when they first present, but you have a bunch of folks from our LGBTQ and pro bono teams who have a wealth of expertise that they're willing to share with you today. Before we dive into exactly what asylum is, just the briefest introduction to NIJC for anyone who might be new. Our mission is to establish and defend the legal rights of immigrants, regardless of background, and to transform the immigration system to one that affords equal opportunity for all. We do this in a number of ways across a number of different case types, but obviously today we're focusing on asylum. But just to give you a sense of NIJC's broad model, we have our direct services, which is the core of what we do. That's what you see on the right-hand side. We serve about 11,000 non-citizens each year across our various programs. And we do that with the support of a network of over 2,400 pro bono attorneys and legal volunteers who take on cases, participate in clinics, and support our work. The trends that we see from our direct legal services cases inform the more systemic advocacy that we do, both through our policy teams, which are locally here in Chicago and in Illinois, but also federally and based in DC, and also through our litigation team. So we think this model is a really beneficial way to identify trends in our client cases and figure out how we can leverage our different tools at our disposal to address them the best we can. And now I'm going to hand it to my colleague to give us the overview of Asylum.
Wonderful. Thank you, Charlotte. My name is Tori. I use she, her pronouns, and I am a senior attorney with the pro bono team. I'm going to talk to you a little bit about what the asylum process looks like, and before we get into the nitty-gritty of each of the pieces and parts of asylum. Jenny, if you could switch the slide, please. Thank you. So asylum is a form of relief that is available to individuals who fear returning to their country of origin. It's a form of protection, meaning it can prevent somebody from being deported from the United States, and it can also lead to a pathway to permanent residence and citizenship here in the US. The definition for asylum is actually the same as the definition for a refugee. The big difference is that an asylum seeker is doing the entire process here in the United States. So in order to be granted asylum, an individual must establish a well-founded fear of persecution on account of race, religion, nationality, membership in a particular social group, or political opinion. And the harm that they fear must be by the government or an entity that the government is unable or unwilling to control. This all takes place in the asylum system. The asylum application process exists in this complex system where an individual can be applying in one of two contexts. The first is affirmative, which means that they're applying with USCIS. That's the federal governmental agency that adjudicates all sorts of immigration applications from naturalization to work permits. This means that a person is not in deportation proceedings and is, in theory, in a less adversarial system. So after the application is submitted, eventually an individual is scheduled for an interview where there will only be an asylum officer, the asylum seeker, an attorney, and an interpreter. This is in contrast to the defensive process, which takes place in the context of the immigration court. So when a person gets to this stage, as my colleagues will explain more in depth later, an individual is saying that they should not be deported from the United States because they are eligible for asylum. This is the last step before the Board of Immigration Appeals, where a party who has lost either side may appeal. The Board of Immigration Appeals has jurisdiction over all of the immigration courts throughout the United States, so they make binding case law for all immigration courts. From there, the case can then take the route that maybe more of you are most familiar with, which is to the federal courts of appeals, and then eventually the Supreme Court is possible as well. So the asylum application is how this process all gets started. This is a form called the Form I-589. We're going over this slide because it is important context, but it's good to know that the majority of cases that we place with pro bono attorneys already have this step completed. So we'll give you a little bit of an insight into what the process that we go through in applying the I-589 looks like. So an asylum application, this is the first page of 12 or 13 pages in the application. an individual is also applying for withholding of removal at the same time that they're applying for asylum. So we'll explain in the next slide that this is a similar but much different in terms of benefits form of relief. An application may also include protection under the Convention Against Torture, which we often call CAT protection. You can tell that CAT is included as part of the application process through this little box up top that you might see. And it's important to know that all applications need to be complete and sufficiently detailed. So one of the things that we have been seeing in immigration courts under this administration is a tightening of restrictions or requirements on how an asylum application can be filed and what it needs to be complete. In the past, a lot of attorneys and advocates have put in more abbreviated answers in the I-589 in the short answers portion, where an individual has the ability to explain why they are requesting an asylum. And in the past, it's been kept more general because we can then elaborate through statements and supplemental evidence later. And the courts have swung in the complete opposite direction, requiring that all applications are very sufficiently detailed. And so this is one of those due process issues that we have to look out for early in the application process. So the application, as I mentioned, encompasses asylum, withholding of removal, and CAT relief. They're very similar applications, but they each have different requirements as well as different benefits. So asylum is a discretionary form of relief. It requires that somebody proves, the asylum seeker has the burden to prove that there is a reasonable possibility they would be harmed in the future. If they can meet all of those elements and meet the discretionary requirements, they can then be granted for asylum, where they can then petition for family members and include derivatives on the application. So for example, if two parents and all their kids are on one application together, they can all win asylum at the same time. They can also get benefits such as FAFSA and the ability to travel abroad, and it puts them on a pathway to citizenship. Withholding of removal is not discretionary. So this is a great option for people who maybe have some unfavorable factors in their case, such as minor criminal history or things like that. But the burden of proof is much higher. There's a much higher requirement for somebody to be able to prove that they will be harmed in the future. They cannot petition for family. Family members are not included as derivatives on the asylum application. They're not entitled to other benefits, including a pathway to citizenship. The Convention Against Torture is very similar. It's not discretionary. It has that higher burden of proof, but there's no requirement to show that harm would be on account of protected ground. Similarly to withholding of removal, there's no additional benefits, and family members included on the application or abroad are not able to derive benefits from the application as well. So as you can see through this overview, the asylum system is really complicated. There are a lot of different factors that go into each case, and non-citizens do not have the right to appointed counsel. So what that ends up meaning is that nationally, 70% of immigrants are unrepresented in their case, and in Illinois, 75% of these cases go unrepresented. This is especially troubling for LGBTQ asylum seekers in this context, where we have seen the government replace gender with sex on all immigration forms, requiring detention based on sex assigned at birth, and just becoming more and more strict on asylum applications in a way that we have not seen before. So this is where your representation is going to make a huge difference. So with that, I will pass it along to my colleague, Jenny, who's going to talk a little bit about working with LGBTQ clients.
Thank you so much, Tori. Hi, everyone. My name is Jennifer. I am the LGBTQ Pro Bono Coordinator, and my hope today is to talk a little bit more about working with our LGBTQ plus clients. Our main hope with this next section is that you'll feel that this will be a learning opportunity for you, and that you'll feel that you'll be continue to be open to learning throughout your time on a case. On the screen here, you see some of the LGBTQ plus 101. This is not an extensive list by any means. There will be many more terms of gender and identity that you will learn. When we work with LGBTQ clients, it is very important to take their lead when it comes to how they identify. And we want to make sure that we can support our pro bono attorneys with becoming comfortable with gender and sexuality to better support the clients that we serve. Like I said, the people that we work with, and the terms can evolve. And so our hope is that you'll be open to learning and not feel that you will always know or have the right answer. Like I said, on the screen is some of the more common terminology that you might hear from some of our clients, but we could have an entire dedicated training on each of these terms and its meanings. The main thing we want you to take home today is that it'll be important to learn some of these terms as well as explore their meaning before you take on a case. But we also want you to know we will share some resources towards the end of the presentation, as well as continue to support you when you're on your case. But back to what you see on the screen, LGBTQ people use terms that are different than what we see here, or even combinations. So for example, a client might identify as gender fluid and also identify as non-binary. So like I said, important to remember that sexual orientation is not the same thing as gender identity. And next slide, please. So upon taking a case, you will receive some information on your client, but that at that initial meeting and even throughout your other conversations with the client, it'll be important to hold some space for introductions and to learn the client's identity and chosen terms. This is one of the main tenets of trans-specific competency, is learning and using someone's chosen name and pronouns, which then supports to validate their identity. It's important to consider practicing on your own time someone's name when you're not with the client, to get used to practicing someone's pronouns or chosen name. Keep in mind that someone might change their name and pronouns more than once throughout the time of your case. Transition can also look very different by individual, and it might be social, personal, or medical, or any of the combinations of these. So not every trans person takes any or the same steps in transition. This is a very highly individualized process. And so some people might want to pass for cis while others may not. Some trans people have access to gender affirming care, which is any medical care that affirms a trans client's gender identity. So a couple of these are hormone replacement therapy, which is a variety of medications that supports the adjustment of the body according to the needs and desires of the person transitioning, as well as gender conforming surgery, which is a variety of surgeries that trans people use to affirm their gender. Next slide. Thank you. And so, like I said at the beginning, our main hope is that you will be comfortable with some of the basic terminology. We ask for you to think before asking about any body parts or sex acts. If you don't need to know, please do not ask. Allow, most importantly, for individuals self-determination in their use of identity and terminology. So allow for your client to identify or to share with you their chosen name and their pronouns. Sometimes this means that identities will evolve over time. And so we hope that you'll be open to evolution. When confronted with a term that you do not know, please react with respectful curiosity. We do not expect for you to be an expert by any means, but we will do our best to support you with resources if you need them, and just hope that you'll continue to be open. Mistakes can happen, and it's okay to correct ourselves and to move on. And so with that, I'll pass it on to my colleague, Matt.
Hi, everyone. My name is Matt Palmquist. I am the managing attorney on NIJC's LGBTQ project, and I use he, him pronouns. And I'm going to talk a little bit about some other, I'm going to talk about the courts that you will be practicing in primarily if you decide to take on an NIJC LGBTQ asylum case. And As my colleague Tori mentioned, there are a few different routes that someone can obtain asylum, and I'm primarily going to be focusing on the immigration courts, also abbreviated as EOIR, or the Executive Office of Immigration Review, because that's where most of our asylum seekers are being pushed to pursue their relief right now. I think it's really important to mention that the immigration courts are under the Department of Justice. They are not Article 3 courts that many of our pro bono partners are used to practicing in. They are administrative courts, Article 2 courts, where every single judge in the immigration court answers to the Attorney General. Problematic? Yes, to say the least. Similar situation with the Board of Immigration Appeals. That is the appeals court above EOIR. Those are appellate immigration judges appointed and fired by the president. And since 2025, the Trump administration has really remade the BIA in his chosen ideology. So you can imagine how difficult it can be to win these days at that stage. However, we do still see victories at the immigration court, and we handle lots of appeals. Just to familiarize you with a couple other agencies, USCIS is the primary kind of affirmative visa granting benefits office in the United States government. We used to see more asylum seekers seeking asylum through the affirmative asylum process USCIS. We see that a lot less now, but there is a chance that we would place an affirmative asylum case with a pro bono team. And if we did, we would obviously go in depth about all the special considerations of that case. USCIS is part of the Department of Homeland Security, which, as you may know, oversees ICE and CBP. Problematic that an immigration granting office is under the same department as the harsh enforcers. Again, yeah. And then finally, I just wanted to mention the Office of Refugee Resettlement. That is an office under DHHS, and ORR primarily handles unaccompanied immigrant children who arrive as they're designated UACs, which stands for unaccompanied alien child, language we don't like to use. But I just want to mention that so that if you do receive an asylum case for someone who used to be an unaccompanied immigrant child, you might see documents from the Office of Refugee Resettlement, and NIJC would help you talk through case strategy as to how that might affect your case. Next slide, please. And so now this is about the all-important document in immigration court called the NTA. It might be a little hard to read, but NTA stands for Notice to Appear, and that's when a case starts in immigration court. This might happen after, as I mentioned, someone has already applied for asylum at the asylum office, which is under USCIS. If someone doesn't prevail there, it isn't an instant no or denial. It's often what we call a referral, where they said, okay, asylum office couldn't say yes, so now we're sending you to immigration court to fight your case again. Exhausting, time-consuming, inefficient, but that's where a lot of our clients find themselves these days. And there's three pretty common ways that someone will receive an NTA. One is after a criminal arrest. If a non-citizen has been in the US for years and perhaps didn't have status, then they get on the government's radar through a criminal arrest, which can be as low as, driving without a license. And, we're lucky here in Illinois where non-citizens can get licenses, but that is not the case in many other states. A second common way folks will get an NTA, and perhaps the most common way for NIJC clients, is immediately after crossing the border to seek asylum. They'll receive an NTA at the border. And the third way I mentioned is after a referral from the asylum office. And the NTA is a very important document in your case, so you want to look at it carefully, you want to review it with your client, and you'll, of course, want to review it with NIJC as well. Next slide, please. And biometrics. So biometrics sounds very AI dystopian, but basically it just means taking an asylum seeker's fingerprint and sometimes other biometric data, which includes their picture of their face, which is a required stage in the background check for someone to be able to seek asylum through any route, through the asylum office or at the immigration court. Sometimes biometrics from other USCIS applications can be reused. So, for example, I think we'll talk about work permits for asylum seekers a little later on, but many of our clients will receive a work permit, which gives them legal right to work while they are waiting the years for their asylum case to process. And as part of the process of getting that work permit, they'll have their fingerprints taken. And there are ways that sometimes those can be reused for the biometrics for an asylum seeker's final hearing. And yeah, this is a very important step. At the same time, it is very hard to schedule these biometrics appointments, especially if someone receives a letter in the mail and they miss it. So this is just something to keep in mind as you get closer to your client's final hearing in immigration court. If they haven't had their biometrics done, clients sometimes don't know this word. So when I'm talking about it with them in English or more commonly Spanish, I just use the word for fingerprints. If they haven't had their fingerprints done, that's something you want to take care of as soon as possible. Generally, this is done through calling the USCIS horrible customer service line and scheduling, but there are also some ways that we in Chicago can get it done through email. And so again, this is something NIJC would partner with you on. Next slide. Thank you. And so in immigration court, there are two types of hearings. And I won't go into depth of all the things that could happen at a master calendar hearing. We'd be happy to do that if you are able to take a case. But essentially, master calendar hearings are like short group hearings in immigration court. Individual or merits hearings are the final hearing in an asylum case where someone has a hearing on the merits of their case, right? That's the argument where you present evidence, there's cross-examination, the judge maybe asks questions. But I just think this is an important overview to give our pro bonos because clients oftentimes don't know the difference between this. And you may remember from last summer, there were lots of arrests at the immigration court. People showed up for their hearings, mostly master calendar hearings, and ICE just put them in handcuffs or zip ties and then took them to a detention center. And it was horrible. And even if our clients didn't experience this, every single one of my clients knows someone who did. And so they're very scared about going to court. And so I think, to the extent you're able to explain to them what to expect, if it's just a master calendar hearing, it'll be very quick. Perhaps you're just going to plead to the NTA. Perhaps you're just going to set for an individual hearing. And then the individual hearing is longer, is perhaps a little bit more stress-inducing because, clients are going to have to flesh out all the details of their asylum claim, which could be difficult or traumatic to talk about. But you would obviously appear with them as their lawyer at that hearing and be very well prepared. So I just wanted to give a basic overview of those different types. Oh, and then of course, always monitor for changes. Sometimes we don't get notices, but there is an online court system that you can put in a client's A number, check hearings, and if you took a case, we teach you how to do that. Thank you. And next slide. And now I will be passing it off to my colleague, Katie McCoy.
Thank you, Matt. Hi, everyone. I'm Katie. I use she, her pronouns. I'm a senior attorney on the Asylum and LGBTQ projects, and I'm very excited to dive into the nitty-gritty of Asylum with you. This section is more legally dense than the other sections, so we're going to have the break in the middle of the section to break things up a little bit. We'll also have a hypo to help you apply asylum law to make sure you're thinking through the things that we think through when we take on an asylum case. So this has already been previewed, but now is when we're really breaking it down that there are 5 elements of asylum. And there are 5, which means you have to separately address and speak through, argue for, identify every single one of these 5. Please do not conflate the 5 elements. It happens a lot. You'll see written decisions from the 7th Circuit, from the BIA that kind of muddy the waters, really kind of conflate or confuse the different elements. And you want to make it crystal clear that every single one of these elements is met on its own and that your client qualifies for asylum and merits discretionary relief. So the first element is actually an emotion, fear. And that's kind of unique, but you are proving that someone has a well-founded fear of return to their country. And this can be based on things that have happened in the past, or solely based on what they fear will happen in the future. Somewhat informed sometimes by what has happened in the past, but it could be something that hasn't happened to them, but they have a strong possibility belief that it could occur to them. And when I say strong belief, it's really a 1 in 10 chance of persecution. That you are setting out that someone has a reasonable possibility of persecution, a 1 in 10 chance that their life is in danger. That's your burden of proof. That's what you're showing to the court. This is both a subjective and an objective element. So you're saying they're afraid for these reasons, for them personally, specifically, but then also objectively, the country conditions support this. There's other evidence. There's maybe an expert. We'll get into all the ways that you support this fear, but subjective and objective elements. And this is different from withholding of removal and CAT that Tori already identified those other forms of relief that you're also preserving when you apply for asylum in the same form, but that has a higher burden. That's more likely than not. That's around 50%. And the Seventh Circuit, at least here, is very clear that you shouldn't be doing a specific mathematical equation to figure out if it's more likely or not when someone's life is at risk. You should really be taking these into account. If there's possibility of serious harm to someone's life, then don't look at it with such a, so don't be so scrutinizing on the percentage with which this is going to occur. Okay, and as I mentioned before, it could be future, which is what we just went over, or it could be past. So if someone has suffered a high enough degree of persecution in the past, which will be the next element we cover, but if that is significant enough, what happened in the past, they already have then a presumption that they will suffer that 10% persecution in the future, as long as things are the same. And the way that that could be rebutted is if things are no longer the same. And that's DHS's burden, the government's burden, to prove or rebut that maybe country conditions have changed, or that there's an ability to move somewhere else in the country to avoid that same persecution that they experienced in the past. We often argue past persecution. I would say in almost all of our cases, we should be arguing past persecution to preserve both opportunities and avenues for protection, either past or future. So the next element is what I foreshadowed, persecution. And that is a very specific legal definition. Every circuit applies their own standard. The Board of Immigration Appeals is trying to heighten that standard right now with almost every decision that they're issuing. So really pay attention to the applicable circuit law that exists. In the Seventh Circuit, we're fortunate to have this broader understanding of what can qualify as persecution. And there are 3 elements. This comes from the case Standikova. First is the significant physical force. So that's physical violence. That's kind of the stereotypical form of persecution that many people think of when they hear persecution or an asylum case that someone has experienced physical harm. Infliction of comparable physical harm without direct application of force. The most stereotypical example there would be sort of starvation or some sort of torture, prolonged detention that results in physical harm to one's body without the direct application of force. And then third is non-physical harm of equal gravity. And here is something that we really want to flag, because this is very common in our LGBTQ cases. This can be threats of harm. If the threats are sufficiently grave, those threats alone can be a form of non-physical harm of persecution. That alone can qualify as past persecution. Also, sexual violence, that can also be significant physical force, but sexual violence you would want to flag or raise or identify. But specifically in our LGBTQ cases, forcing someone to abandon their identity, their gender identity, their sexual orientation, they're not able to be open without experiencing persecution. That is a form of persecution in and of itself, and you should be raising that. You should be identifying it, talking about the psychological harm that someone endured because they were not able to be open and true to their own identities. And then something else too, which goes along with that, forced marriage can be a form of persecution. Things to flag: harm that someone experiences as a child can be lesser than what someone experiences as an adult to qualify as persecution. So even if you have a client and you meet them in adulthood, identify what occurred to them in childhood that maybe informed their adulthood and how they were or were not open with their sexual orientation or in their life generally. So anything that happened throughout their life, connect it also because harm must be considered cumulatively. There's both BIA and Seventh Circuit law that says that. So throughout their life, what they're experiencing, you want to show specific instances of harm and also the backdrop that's going on that further exacerbates the persecution that they have experienced. So you're meeting that level of past persecution and also helping to show future persecution. Here's our first hypo, and I'll flag that we do have a poll. So I'll read through because it's the same hypo throughout. I'll read through this first time and be thinking about what facts of this hypo are important for persecution. Martha, who uses she, her pronouns, is a trans woman from Colombia who is currently in removal proceedings. Although she was assigned male at birth, she knew from a young age that she was a girl and that she was attracted to men. When she was younger, she often wanted to dress like her sister, play with the same toys, and wear her hair longer. On a few occasions, when her father observed her playing with dolls or dressing in girls' clothes, he beat her and called her names. As an adult living in Colombia, Martha decided she would not medically or socially transition and avoided dating men out of fear of being identified as a member of the LGBTQ community. She was able to connect discreetly with other LGBTQ individuals through an online community and later formed a small group of LGBTQ friends in person. After one of her friends, who lived openly as a trans woman, was killed, Martha became terrified for her own safety and fled the country. Okay, I think we'll send out our first poll. Here it is. So what facts would you highlight as important to past persecution? It says single choice, so maybe pick the one that you think is strongest, but I will just say that they can be more than one. Okay, great. Okay, so yes, good job, everybody. Nobody selected Martha playing with her dolls, which is a red herring. We'll get into what that is good evidence, and that is definitely evidence I would include, but it does not go to the element of persecution itself. Beatings by Martha's father, yes, absolutely physical harm that she's experiencing, including as a child. So the harm that she's experiencing as a child, beatings may be lesser than something that someone in his adulthood suffering a beating might have to show past persecution. The murder of Martha's friend, that's going to psychological harm, that's informing her fear. So yes, definitely identify that. And Martha hiding her identity. Absolutely. Her inability to be open as a trans woman, especially informed by the factor we just said that her own trans friend who she was close with, who was living openly, was murdered. These are all things that I would flag for past persecution. Great job. Okay, so yes, we're on to the third element. So this is the who part of the case. I will flag that there is a bias that right now who the persecutor is, I mean right now always, the government tries to make the argument that the persecutor should be a government entity and try to make it much harder to establish when a private actor is the person doing the persecution, that it shouldn't qualify. But the law, the legal standard that the Immigration and Nationality Act says an entity the government is unable or unwilling to control. So they cannot read the text out of the statute. And so what you're doing whenever you have the past persecution, you have the persecution, you're thinking, who is doing that? Is it a government agency? So is it a police? Is it security, military forces? Is it a village chief? Depending on what the structure of the government or the bureaucracy looks like in that country. And then sometimes maybe you're saying, is it a paramilitary actor? Is that a gang? Do they have de facto control of that country or that community in which your person resides, such that you can argue that is a government actor? Or is it a quote unquote private actor, meaning could be still gangs and military, paramilitary. It could be a guerrilla group. It could be family members. If, for the example from Martha, her father, a vigilante group, maybe associated with the government, maybe not, depending how you're framing that, depending what you find out. And non-ruling political party, others. Identify who that actor is and how are you framing it. So you can then make the argument about how the government, that is the government, or the government cannot control this person or actor. So these are the things that you want to think through also when you're thinking through the unable, unwilling to control element. One of the first things you want to identify is in that country itself, what are the laws on LGBTQ people? Do they already have laws making it illegal to be queer, to be involved in an LGBTQ organization? Then you can argue de facto the government is a persecutor just by the law that they're implementing alone, that they have made their identities illegal. Are government officials saying transphobic statements or homophobic statements that you could attribute that government actor, government policy, government culture is oppressive to your client? If it's a private actor, you want to flag always whether someone reported that harm to the police. If they did, how did the police react? Did they take it seriously? Did they write it down? Or did they tell them that's not a crime that they investigate? Those are important factors to show why the government can not or is unwilling, unable to control the private persecutor, if there is one. And it's important to note that if someone does not feel safe reporting because that would put their life more at risk, they are not required to do so. There is Board of Immigration Appeals case law that I will say is being cabined. They're trying to make that really narrow avenue of exception for folks to not report to government actors. There's also some Seventh Circuit case law that's good, some that's less good. But you want to be showing why it's unreasonable, it's unsafe, it's futile for someone to report to a government entity because the laws make it illegal for them to do so, or they know people who have experienced harm when going to ask for protection. So think through all these things when you're arguing the unwilling and unable element. Okay, that takes us through 3 of the 5 elements, and now I'm going to give us a 5-minute break. And so you can digest that information before we come back with Tori to talk through the final 2 and some of the most important, usually where someone wins or loses an asylum case, the on account of and protected grounds. It is 10:15. Let's come back at 10:20.
Okay, everybody, it is 20 after the hour, so we are going to go ahead and continue on with the asylum elements. We have now reached element 4, which is the on account of prong, also called nexus. So we will talk in the next little section about what a protected ground is, but it's not enough for somebody to be a member of a protected ground. There has to be a connection between the persecution that Katie talked about and this protected group in order to meet the elements for asylum. So one thing that is critical when it comes to arguing this nexus is that the protected ground only has to be one central reason for persecuting the applicant. That means that it does not have to be the sole or even primary reason that the persecutor is harming the asylum seeker. It can be a secondary, tertiary reason and still justify asylum. The way that we can demonstrate nexus is through things like circumstantial evidence or the timing or words of the attacker. So this is a great time to really work closely with your client to get the context of the harm that they have experienced. Things like using slurs or demeaning language in conjunction with physical harm can be helpful. If somebody is transitioning and they have started to present more femininely or more masculinely, and then they start to experience more harm and prejudice in their life, that's a pretty good connection that we can use to show there is this connection between the harm experienced and the protected ground. So we will do a quick little return to this hypo. We're returning to the same hypo. It's Martha, who is a trans woman from Colombia who experienced some harm from her father as a young child and had to live in the closet while in Colombia. What kinds of facts, and you can put this just in the chat, what kinds of facts would be helpful in establishing this connection between Marta being trans and the harm that she experienced in her past? Country conditions are great. That is a great way, Michael, to establish kind of the greater context of harm against LGBTQ. And yes, Marian, I agree that the father watching her play with dolls and then following with a beating would be the number one thing I would point to, in addition to news and country conditions that can help establish that circumstantial evidence of trans people experiencing harm in Colombia. Great. Thank you, everybody. So moving on to the protected ground element, there are a number of different grounds that are protected to help demonstrate that a person qualifies for asylum. As we kind of discussed a little bit in the Q&A and webinar chat already, you can select one of these, you can select all of these as long as the facts kind of give rise to each of them. So it's important when working with an LGBTQ client to not just focus on sexual orientation, but to also explore other possible avenues. So other protected grounds include race, which is typically pretty broadly defined, the example here being Congolese Tutsis. Another example is religion. So that can be somebody who's a member of any one particular religion, Christianity, Judaism, or it can even be differences of interpretation within one religion. For example, the way that the Taliban interprets Islam is probably going to be very different from the average practitioner of Islam in Afghanistan. Nationality, which can include not just citizenship, but also a linguistic group. We can also do political opinion, which is kind of the famous example for asylum. And that can be somebody's actual political opinion, or it can be their imputed political opinion. So an example of an actual political opinion would be somebody protesting in marches, somebody who is organizing with a political group or a political party, whereas imputed political opinion can come from somebody's actions or other memberships. So for example, perhaps an LGBTQ individual is associated with a certain political party in a country, and therefore their membership in the group can lead others to impute a certain political ideology on them. Lastly, and this is where you'll find your home in an LGBTQ asylum case, membership in a particular social group, which we call PSG. This is sort of just an amalgamous catch-all group that would encompass individuals who belong to a group that shares a common immutable characteristic. So let's get a little bit deeper into what exactly that means. So the PSG that you argue in a case must be both cognizable and your client must be a member of that group. A PSG is cognizable when it is centered around a common immutable characteristic, something that somebody cannot change about themselves or should not be required to change about themselves. Sexual orientation has been long recognized as a cognizable social group since the 90s. It has been consistently reaffirmed across case law. Gender identity is a little less clearly established, but there are cases that recognize trans individuals to be a member of a cognizable group. That argument exists that while an individual's presentation of their gender might change over time, they should not be required to change how they present or how they identify, especially at the behest of the government or a private actor. Sexual orientation can also be imputed. So we see this a lot with claims based on HIV status. This is in a lot of countries where there is misinformation about what it means to be a person living with HIV, and assuming that people who have HIV have to be members of the LGBTQ community, that only people in that community get diagnosed with HIV. And so that's a really good example of times to argue an imputed claim. Another example of this might be for trans individuals. A lot of times people who are anti-LGBTQ in a specific country might not recognize that person as their gender. So they may not recognize a trans woman as a woman, and there may be reason to preserve that they may be imputed as a gay man back in their home country, which can help in this context, in this terrible context where the identity of trans folks is really under attack. And so preserving that they may not just be seen as a trans woman, but may be perceived as a gay man is sometimes helpful to preserve as an argument in a brief. So we will return to Marta's hypo with a little poll, and we would ask, as kind of a hypothetical, if you were filling out the I-589, which again in most cases is already completed in your case that we would assign to a pro bono, what protected grounds would you put as the basis for Marta's claim? So let me put up the poll. You can argue any one of these. In the I-589, there is also the Convention Against Torture, which you select both at the first page, like we demonstrated at the very beginning, and then also when you're selecting protected grounds. Give everybody a second. Okay, I'm gonna share this. So looks like we have a pretty good spread of answers. I definitely agree that particular social groups should be checked. That's going to be probably where we make the majority of our argument. Convention Against Torture is also probably going to be checked. That is something that would probably need a little bit more screening to ask the client, you know, what exactly do you fear being harmed? If somebody fears being harmed, which is likely based on the murder of her friend, that would be a good reason to check Convention Against Torture. Political opinion could definitely be there. I'd definitely want to screen the client a little bit more to kind of get a sense of that context in Colombia. Religion is also a really interesting one. You can see that a lot. People who believe that being an LGBTQ individual is compatible versus incompatible in their religion is definitely something that could be explored. I don't necessarily see anything here that might indicate race or nationality, but that is always fact-finding that we should be doing to make sure that we're not missing any protected grounds. Okay, so with that, I'm going to pass it back to Matt, who's going to talk about some other key consideration in asylum claims.
Great. Thank you, Tori. And yes, so I'm going to talk about some other key considerations in asylum claims. As we've mentioned a few times throughout this presentation, each of the slides and sometimes the subsections of the slides that I'm going to talk about could be a whole presentation of their own. And so, these are nuanced legal issues, and feel free to drop questions in the Q&A. I love that people have been using that. But, we're mostly just answering these other considerations so that you can know the name and know to look for them in your case. But if they present in your case, NIJC will work with you to formulate a strategy. So first, I just wanted to cover some of the bars to a grant of asylum. We don't see, some of these we see more than others, and I'll focus on the ones that are more common in the cases that you might accept from NIJC. So first of all, in order to qualify for asylum, instead of withholding or cap protection, you need to file your application within 1 year of arriving in the country, which for many of our clients is within a year of crossing the border. If you don't, you can qualify for an exception under two different kind of buckets of circumstances called extraordinary circumstances or changed circumstances. Extraordinary circumstances often encompass legal or medical disability is the word that the regulations use. Serious medical issues, and this can include mental health issues. So for example, if someone was grappling with very severe PTSD from harm that they experienced in their country and they were struggling to survive and obtain services, and they missed the 1 year filing deadline to their asylum application, that is an argument that we can make. And we would, however, just need to be sure that that's backed up with evidence. And so oftentimes evidence we would use is a report from a psychologist or a doctor, a medical professional. Changed circumstances is something that we often encounter with our LGBTQ clients. A very common one is undergoing gender-affirming medical care. Many of our clients who identify and live their lives as transgender women, when they arrived in the United States, they identified as gay men. And I think the reason for that is they came from countries and cultures where LGBTQ issues weren't talked about. And so, a lot of my trans clients have told me that the first time they learned of the existence of transgender identities was in the United States. And so a lot of times they came to the US because they were seeking safety because they're queer, they had experienced harm on account of that, but maybe, well, almost certainly they had not been given the space and safety to discover their queer identity, and so they undergo gender affirming care. Undergoing gender affirming care and becoming more visibly transgender can count as changed circumstances for an exception to the 1 year filing deadline. And so these other bars, I'm going to go over more quickly because we just don't encounter them as much. The terrorist-related inadmissibility grounds, TRIG, sounds scary and has become more complex since January of 2025 when Trump essentially recategorized a lot of the international drug cartels as terrorist organizations. And if someone provides support to one of those organizations, they can be barred from asylum. This is very complicated for our clients who come from countries where coexistence with these cartels is necessary for survival. Like, you need to be, like, even if you aren't an active part of their criminal organization scheme, they're your neighbors, they're your customers. Sometimes you have to pay them in order to walk down a certain street. And so that does present issues, and we are seeing this come up more in immigration court. But again, if your case presented these issues, NIJC would help you talk through them. A few other bars that I'm really just going to mention by name with a quick explanation. Firm resettlement is if an asylum seeker lived for a long period of time in a third country before entering the United States. For example, we see this a lot with our Venezuelan clients who oftentimes live several years in countries in South America near Venezuela, like Colombia, Ecuador, and Peru are the most common ones, before coming to the United States to seek asylum. And so then DHS will argue that they were firmly resettled in those other countries and they cannot receive asylum, but could still potentially receive withholding or cap protection. And then, of course, previously denied asylum applications, if someone's had their application denied, they might be barred from receiving asylum now. If there's a safe third country that they pass through, they cannot seek asylum, and then certain criminal related bars to asylum. And yeah, so now let's talk about applying the bars. So Martha, our example asylum seeker, applied for asylum after her 1-year filing deadline. She had been struggling with her mental health and was going to therapy. Almost a year into her time in the US, she started growing her hair out and wearing makeup. She also started to ask some friends to call her by her chosen name, Martha. I'll pause there, and then I'm wondering if folks could drop in the chat, what bar do you think could be a problem for her in her asylum application? And it's really easy. It's in the first sentence of, yes, thank you, darling, 1-year deadline. Can anyone think of facts in this first bullet I've read that might qualify her for an exception? Yes, thank you, Kara. Yeah, the medical issue, changed circumstances, growing her hair out, using a chosen name. Thank you, Kevin. Therapy. Yes, so visibly transitioning, these would generally qualify as changed circumstances. Good job, all. And so number 2, Martha lived in Mexico for 6 months before coming here to the United States. She did not apply for any immigration status there. What bar do you think DHS might argue based on these facts in her case? Yes, thank you, Marion. Firm resettlement, exactly. Yes, possibly third country. In the first Trump administration, they did try to argue that Mexico was a safe third country, and I think that litigation failed, but we expect everything these days. And then finally, while living in Mexico, a couple of gang members who told her they were members of Carteles Unidos threatened to kill her if she didn't give them money. She gave them all the money she had to save to travel with, about $500. Could this implicate another bar to asylum for Martha? Or if you were a harsh DHS attorney dead set on excluding everyone from asylum, what would you argue? Yes, trade, terrorism related inadmissibility grounds. Great job. You guys are all ready for your first merits. Moving on. Now I'm going to talk about a few tips we have working with our clients. I know all of you are great lawyers, but working with asylum seeking clients, especially in today's climate, does present some challenges. And so I'm just going to go over some of those special considerations and any potential challenges. So some tips for while your client's case is pending. Work, these cases take years. Jenny and Charlotte will talk more at the end about kind of our pro bono timeline, but a lot of times, you'll be waiting for a hearing and your client will be like, what next? What next? What can I do? So here's what you can do. Identify and gathering corroborating evidence. This can take a long time, especially if someone has evidence they need from abroad. For example, medical documents. One time I had a client who he was fleeing his country based on family-based persecution. And so he got a copy of his brother's death certificate from his home country. It was very sad, but that took a while and it was important to evidence in his case. Working on the declaration or the affidavit, which is basically your client's whole story, is also very important and takes, it's not just one pass through. Working on a good declaration can sometimes take weeks to months, particularly if a client speaks a third language that requires an interpreter. Monitor your client's case for the annual asylum fee. Clients hear a lot about this on social media. They'll have lots of questions. They'll remind you, but yeah, it's important to make sure that the client's fee is paid so that their case does not get denied or dismissed. Connecting your client with a therapist or a medical doctor for evaluations as appropriate. This isn't to say that you need to set your client up with weekly therapy at a provider. This is more for the evidence angle, where if your client, suffered severe persecution in their home country, that perhaps led to mental health issues. NIJC can help. We know some doctors, therapists, psychologists in the community who are able to provide evaluations for immigration cases. And of course, just keep contact with your client. As I said, there might be periods where there isn't a lot to do, but they will be your client. You'll be representing them, so please stay in touch with them. Employment authorization. Again, this could be a presentation of its own. For those of you who have done pro bono immigration work, you know that the employment authorization is all important. So initial EADs can be applied for 150 days after someone has submitted their asylum application, so 5 months, and then you can put the application in the mail. Initial EADs generally arrive faster, and there's some class action lawsuits to this effect, and if that is something needed in your case, NIJC would fill you in and help you out. A lot of the clients you receive from NIJC might already have their EAD, and so they might need you to help them with a renewal. There are fees now associated with both of these. I know that the fee for an initial first-time EAD is $560. I think the renewal is more. That's a lot for a lot of people on this call. Just imagine how much it is for an asylum seeker who's trying to make ends meet. And yes, just confirm you're following current guidance. I just want to flag that for clients with criminal history. Sometimes certain aspects of that needs to be disclosed in the EAD application. But of course, NIJC will be your point of contact guidance, and we would review your filing. Detention. This is also something that is front of mind for clients and all of us right now. So if your client is detained, we just want to drive home 2 big points before I talk a little bit more about detention. One, the case will move on an expedited timeline. And, you might have a client who has their final merits hearing at the Chicago Immigration Court in May 2028. If they end up getting detained, they could have that final merits hearing within 3 or 4 weeks of entering the ICE detention center. Second, we do want to emphasize that NIJC expects our pro bono partners to stay on a case if their client is detained. And I know that sounds intimidating, but sadly, due to the moment we are in, that's something we've dealt with a lot. Current longstanding clients being detained and having to kind of hit the ground running on an expedited timeline. So we are very eager and ready to support you in that, but we just don't have the capacity to take in a case from a pro bono after someone has been detained. And so just some important reminders, some non-citizens are subject to mandatory detention. This generally has to do with their manner of entry or any criminal history. And yeah, there used to be this thing called bond. There kind of sort of still is. I used to work as an immigration attorney at a nonprofit in Arizona. Bond was a big part of what we did. The government has rewritten a lot of the rules to make bond much more difficult. And then finally, conditions in ICE detention were always bad, as I saw at my previous job, and they've gotten worse. And it's hard to accept as lawyers who want to fight for our clients and want to fight against the system that sometimes what's best for our client is what they decide is best for themselves. And that can mean giving up on their case and going home and accepting a removal order or something called voluntary departure, which essentially is getting them home. So we just want to want folks to keep that in mind as well. We empower our clients to make the best choices for themselves, and sometimes that choice is to stop fighting their case. And working with trauma survivors. So it requires new skills. And, sometimes it can be a little frustrating for us as advocates when we have clients who ghost us for meetings, who are late, who might not, who would struggle to present their story in a chronological order. Sometimes there are a lot of barriers to building trust. And so, some tactics we have for you on that are meeting frequently, again, to build trust and for a limited duration. Ask short questions, and I often sort of arrange my questions based on what I think is easier to ask. And then once trust is built up, asking and talking about the harder topics. So for example, if a client has sexual assault in their background, that's not something I'm going to ask about in the first or second meeting. The first or second meeting is a lot of times just getting to know each other and, maybe talking about their childhood, where they're from, where they lived. And yeah, explain the objective of your questions. Sometimes clients might be like, why do I have to tell you this all the time? Asylum law is weird. It requires us to prove certain things. But sort of explaining that to clients, and then that's also just a way of pulling them into their case and sort of empowering them to be in control. And then finally, we just like to show this to our pro bonos. This is Maslow's hierarchy of needs. Maybe folks have seen this before. A lot of us, I don't want to make assumptions, but a lot of us in this call, who are lawyers, we are in a privileged place in society. And so, we're probably more at the top of this pyramid. We're able to experience great things like self-actualization. We're able to better our condition and fight for our clients to better their conditions. We just want to remind folks that many of our clients are struggling with meeting their needs at the bottom of this pyramid. Many of them do not have reliable, safe food and shelter. They cannot meet their physiological needs. We have clients who sleep in their cars, and when you can't meet your basic physiological needs, it's really hard to be at the top of the pyramid of self-actualization and focus on your immigration case. And so, that's why it can sometimes be a struggle. And then, not all of our clients are in that situation, but I will say that the second level of the pyramid, safety, for every single one of our asylum seeking clients, there is a fear of detention. And the horrible way that immigration laws are written is that almost any non-citizen, including an asylum seeker who is doing everything the right way, can be detained by ICE. And so that threat to their safety of ICE detention by some masked goon on the street, is something that they are struggling with. And so because all of our clients, they don't feel safe right now, it's hard for them to meet those higher levels of the pyramid. And that can sometimes impede the attorney-client relationship a little bit. But of course, we successfully work with all of our clients, and we're ready to support you in that as you do as well. And now I will pass it off to my colleague, Katie, again.
Thanks, Matt. I think we're actually going to take another 5-minute break. I love a 5-minute break. They're great. So it is currently in Central Time, 10:49. Let's have everyone come back at 10:54, even though it's an odder number, 10:54. Please come back. We'll turn our screens on, but take time to move around, get your body moving so that we can power through this last part of the presentation. We've loved your participation so far. Thank you so much. 10:54, we'll see you again. Hello, everyone. I'm going to welcome you back now. And by my clock, it is 10:54. So let's get started on the last few sections we have for you. This is more putting everything into practice, assuming that you're so inspired by our presenters today that you are feeling called and ready to take on a case. This is giving you the exact how to hit the ground running, what you need, what to look for, and where to go for the next steps. So, you've accepted a case. Yay, that's great. And we'll give you more information in the end, what kinds of cases we have right now and how to get in contact to accept a case. But assuming you have already accepted a case, first stop shop, go read our procedural manual for asylum representation. It is very thorough, it is long, and it has a lot of really good hints, sites, different things that you could use. A lot of your first questions that might come to mind, if maybe we didn't cover them in this presentation, are really well outlined and answered in that manual. It is live on our website. It was recently updated. I'm giving a huge plug for it because I think it's pretty excellent. My colleagues did great work on that. You'll also want to review the case file. As we've said, we've already done a screening intake with your client. In more cases than not, we've already filed the asylum application, and we might have done the master calendar hearing. So those are reasons why that part of the presentation might have seemed a little faster for you all, because we're assuming in most of these cases, you're jumping in to represent on the individual merits hearing. So you want to review everything that has happened so far and what needs to be done. If you have never practiced before the immigration court before, you are required to register and get a specific e-registry ID number. This number, currently, the way that you have to get that ID is to go to the immigration court and show your ID, but it is a fast process, just requires you to physically go to the court. And then from there, you can file your E-28 with the immigration court to show that you're the attorney of record. If you have an online case, that means you should be getting notifications to your email right away if something else is new or happening in the case, and you can upload your own filings there. If it's a paper case, you should still be able to see if the hearing date changes. Just know that you would get a mailed notice rather than have it in your account. And from the beginning, check for any of those deadlines. So the things that Matt flagged for you, your annual asylum fee, if you need to pay that, if you have an EAD, a work permit that's about to expire, really pay attention to that because now there's no longer automatic extensions. So you want to make sure someone doesn't have a gap in their work authorization. You're filing for that timely if they need that. Mark down every single deadline that could be relevant to your client so that you're well prepared to keep them as highly centered on the Maslow hierarchy of needs as they possibly can, because you're really well prepared and keeping them updated too on what the next steps are in the representation process. Okay, I flagged this, but we created a special slide because it is confusing and does trip people up. So as I said, the form on the right, the E-28, that's the document that you use to show that you're representing a client before immigration court. EOIR, Executive Office of Immigration Review, has the E-28. That's where you need your EOIR ID. That's what goes before the court. The form on the left does not go before the court and should not be filed with the court. That form is for notifying USCIS, ICE, CBP that you're representing a client. Even if you're thinking, I'm just representing the client in court, I don't have to update an EAD, I have no reason for the G28, we still recommend getting a wet signature on the G28 to have on hand and ready to go in case of emergency, in case your client gets called to an ICE check-in, in case whatever, you already have that executed form showing that you represent your client for whatever needs may be. So the first time you meet with your client, you want to get the form on the left signed, the form on the right, the E-28, does not require your client's signature. And fun thing about immigration proceedings, there is no discovery process. So for those of you who are used to working in Article 3 courts or normal courts, you don't have access to discovery. You have to figure out what the government has on your client. And the way to do that is most commonly and pretty uniquely through a FOIA, a Freedom of Information Act request. And you might have to do it with these various agencies. Probably not all of them. Talk to NIJC if it makes sense to do all of them. Some of them have combined processes, and some of them might just not be relevant to your client. Most commonly, you want to do a FOIA to USCIS. In theory, that should get you most of the evidence that DHS has on your client. I will flag that right now the process is quite tedious. They are rejecting a lot of them and they're constantly changing their requirements. So talk to us about what the current trends are and be prepared that a lot would be redacted. They love to redact things right now and say that we don't have access to them. I do believe the FOIA request information is in our manual. You can also reach out to us. We have a lot of how-to guides that we are changing and developing because the trends are changing really quickly, as I mentioned. So we have a how-to guide, and we'd love to share that with you if you all are accepting a case with our clients. The DIR, digital audio recording, that's if your client has already had some hearings in court. EOIR, if they had prior proceedings that you were not representing, you wouldn't have access to them on the online account. So you might need to request the full record of everything that has happened in court proceedings. And if your child or your client was a child when they entered the United States, an unaccompanied immigrant child, then you might need to do a request with the Office of Refugee Resettlement. So on your first meeting, as we highlight in red there, you are not getting into the worst of the worst experiences of your client's life. We don't believe that's the best way to build rapport with your clients so that they feel trust in you if you start digging right away into the most traumatic experiences. More likely than not, it's going to make someone shut down rather than feel open and safe talking to you. So we encourage your first client meeting to be just focused on rapport. You're going to do introductions and small talk. You're going to make a plan like, hey, what is your work schedule? What do you think timeline works for you? Would you rather do things more consecutively or more spaced out? Would you rather phone? Would you rather in person? Would you rather video call? Figure that out for your client as much as you can. Give them agency in having these meetings with you in something that feels more comfortable and more safe for them. You're more likely to have them showing up and prepared to discuss the hard things that you probably have to discuss to develop their affidavit and prepare and represent them on their case. If you have an engagement letter, set that. Let them know the expectations of which days are affidavit days, which days probably are going to be heavy, like how you anticipate working in the timeline. Sorry. And then, as I flagged before, you want to sign any forms necessary in the beginning, an engagement form, the G28 to have their signature on file just in case without dates. And if you're getting a FOIA, you have the FOIA forms signed by them already. If you don't speak the language of the client you're working with, you might be working with an interpreter. Even though the interpreter's there, you should still proceed as though you are having a conversation with your client. And what I mean by that is that you are maintaining eye contact with your client. You're asking questions to your client. You're not saying, hey, interpreter, ask them this question. You are saying, how was your day to your client? There are guidelines. We have really helpful resources to really break down how to work with an interpreter. It is a little bit of an art form and something that might take both of you getting used to if you've never done it before. It is also a really good practice because in court, they might have to have an interpreter if they don't speak English. And so getting used to speaking in shorter phrases, both you and the client, getting used to asking clarifying questions, and then taking breaks because interpreting itself is really exhausting. So you don't want to do more than 3 hours. I would say that's really hitting the max for how long one interpreter is usually at their best optimal interpreting skills. And I will flag AI, a lot of people want to figure out if AI is helping us optimize the way that we are doing our jobs. Nonprofit caution that there are ways that it is helpful, but also want to be sure that you are double checking anything that is being produced with AI. There have been big flags both from the immigration court, the attorney general, and even federal courts recently are cracking down on AI, generative AI, using hallucinating cases. So even if you are going to AI, if you choose to use AI to look for resources as a starting point, really make sure you are verifying every single thing, every single case that you are referencing is good law and is a real case. Your clients, especially if you don't speak their language, might be using AI to auto-interpret certain things. If that's being used to schedule a meeting or something more straightforward, if it's more convenient, if it works, it works. But I would definitely not use AI for full translation services. You need to have an interpreter who is fluent in the language, who sometimes maybe like even with people who are fluent might use a word that your client or you don't understand, and you want to make sure that word is accurate when it's translated. So you need a real person who can certify any written translations, and your affidavit for certain needs a full interpreter, someone who is able to certify that they completed the translation and it's true and accurate to the language and the intention that your client meant. And beware that EOIR, like I mentioned, is also wary of AI usage, that there could be penalties for using AI that you're not double checking. And then both USCIS and EOIR seem to be using AI themselves. So I would just flag that too. Okay. And here are the three main components of an asylum case that you will be preparing. These are the things that go into building a strong asylum case in preparation for the merits and also for an asylum interview if that were to be the case. But the main evidence, usually the strongest evidence, is the client's testimony and written affidavit. So that's what you're spending a lot of your time with your client doing. Tori's going to give a more in-depth breakdown of all of these different elements. I'm just previewing what they are. You're also having the corroborating evidence, that's your objective evidence more so, and anything that is specific to your client, to say that their affidavit, their testimony is credible based on country conditions, based on friends, other people. That's great. That's really useful. And then you also want the legal argument. That's where you, as an attorney, are really putting your degree to use because you're matching the corroborating evidence and the affidavit with all of the legal elements that we broke down and showing why all five of those separate elements are met by your client in the legal argument. And now I'll pass it to Tori to break those down.
Great. Thank you, Katie. We are going to start by talking about drafting the affidavit, which is the most important evidence in your case. Technically, a person's testimony can be enough to prove all of the elements in an asylum claim where corroborating evidence might not be available. So this is going to be critical in giving the judge the preview of your client's case, as well as a springboard for credibility and how the judge might look at your client's testimony versus written testimony in the affidavit. So an immigration judge can make a credibility determination based on demeanor, candor, inherent plausibility or implausibility, and consistency of statements that are made at any point. So the immigration judge is going to have access to a wide variety of documents, especially if ICE or DHS is filing early immigration documents, such as the record when they may have entered, called the I-213, or a credible fear interview, which may have been conducted before the individual was placed in removal proceedings. They're going to look at a close eye with each parts of these written testimonies. So it is very critical to spend a lot of time here on the affidavit. So when preparing an affidavit, there are a lot of different things that we should be thinking about. So that includes maintaining the client's voice. That can be a little bit tricky to do, especially through an interpreter, but remaining honest, or not honest, but remaining very closely to the words that the client is using. Sometimes that might mean that they're using phrases or language that we might not use for the LGBTQ community anymore. Sometimes that might mean some turns of phrases that you might not personally use, but it's important to maintain the client's voice so that it sounds like what they're going to testify to on the stand. It's really helpful to craft the events in chronological order, and also provide necessary background information. So it is helpful to sometimes provide context. In the case of Marta, for example, her childhood and her experience growing up is going to be really important to understanding her experiences and why she fears future harm. But again, following that chronological order so that it's easy for the judge to understand is really helpful. Although sometimes it can be difficult to get an affidavit out of a client in chronological order. So this is why it's really helpful to meet early and often to kind of give yourself time to explore everything and then maybe go back and put it in chronological order. We recommend covering all the 5 W's and H, so who, what, where, when, why, and how, making sure that by doing that, we're also covering all the asylum elements. These are the facts of the case. These are what you're going to be using to argue that your client meets all 5 elements of asylum. And so it's really important that there are facts for each element present in the affidavit. It's also important to consider the length in detail and checking for consistency with other documents. So as I mentioned, there are other immigration documents that maybe you get through a FOIA, the I-213, the record from credible fear interview. It's important to look at all of those documents. Maybe you have police reports or letters of support from friends or family. It's really important to make sure that everything lines up and making sure you understand if there is an inconsistency, why it exists, and maybe if there was an error or if there's a good reason for an inconsistency. When it comes to length and detail in an affidavit, this is a really tough balancing act because we have to keep in the forefront of our minds that this is what is going to be used to judge in part a client's credibility. So we have a little example here of what different kinds of drafting in an affidavit and kind of how we approach that balance. So one thing that's really common and helpful to avoid is too much legalese. It's not, sometimes people use language that we might use in the legal argument, but oftentimes they won't. So avoiding things like this first box here, I was persecuted because I belong to the group of Salvadoran homosexuals. Not a lot of people speak like that, and so it's helpful to rephrase it in the language that the client might use, or maybe in simpler terms to avoid looking like we're making legal conclusions in the affidavit. As I mentioned earlier, it's really helpful to keep in the client's voice. So here in the second box is an example of where it doesn't really sound like it's coming from the client. So when I told them I did not want to join their gang, they became more menacing. This triggered a melee with the whole group involved in kicking me and bellowing homophobic slurs. Some police belatedly came to ostensibly investigate, but their investigation was cursory and superficial, and no arrests were made. So this is like really flowery language. Again, sometimes people do speak like that. You work with journalists or people who do write for a living, but oftentimes people don't speak like that. So it's important to stay true to the client's use of language. We also want to balance having enough detail with too much detail because, again, the consistency between the client's statements on the stand versus in their written affidavit is going to be really critical. And so keeping in mind that somebody might get on the stand and freeze, somebody might get on the stand and be really stressed out and get confused by questions, it can be helpful to kind of simplify details. So for example, in this third box here, on May 1, 2010, 3 gang members stopped me after school and threatened me while shouting anti-gay slurs. Details like the exact date, the exact number of people who are there, may be things that are easy to forget on the stand, especially as time passes from the time that they maybe write the declaration to when they testify. So a balanced approach in this last one would be around May 2010, a group of gang members stopped me after school and threatened me with anti-gay slurs. So then we're kind of covering the 5 W's and H while still leaving room for the client to be human when they get on the stand. Another thing that can be really difficult is accounting for cultural differences and remembering that our clients are coming from all sorts of different backgrounds, from countries that have a lot different traditions and cultures than ours do. And so that means that clients may not describe themselves in a way that we might expect them to here in the United States. So it's really important to make sure that you are talking to clients about what terms mean that they might use. And if you want to use a different word in English to describe the client, it's important to talk to them about it and why you think it's important to use terms that might diverge a little bit from what they're used to using. For example, a lot of clients might not have heard the term transgender, and there might be interpreters that struggle to accurately interpret this. So it's really helpful to be having an open dialogue with clients, coming in with the spirit of wanting to understand and best represent your client's experiences and identity. And some things that can be helpful with this are examples of like terms. So for example, if a client says that I am gay, a really helpful follow-up question to that is, what does that word mean to you? Sometimes that's an umbrella term. Being gay might encompass somebody who is a lesbian or somebody who is bisexual. So it's important to know, what does it mean when you use the term gay? Then following up with other questions like, how long have you identified as gay, are really helpful too. It's best practice not to ask, how long have you been a homosexual? We typically avoid the term homosexual, as we'll talk about later in this presentation. And this kind of implies there was a deciding moment to be a member of the LGBTQ community that we want to avoid. If a client is trans or gender nonconforming, asking what other names they use, what pronouns that they prefer to use can be really helpful as well. Although it's important to know that this is, again, one of those areas where people might get confused by this question. They don't necessarily have the language or have heard the language that we would use in the US. So even adapting questions to be like, do you prefer that I use senor or senora or neither of these when working with a client is going to be really helpful. And then most important is to check in with the client about what contexts are okay to use their chosen name and pronouns, or talk about if they have a partner here in the United States. They may not be out to family, friends, or roommates. A lot of times the asylum process is happening in the context of their possible deportation. So they may not be living fully out here in the United States out of fear that they may have to return to their home country. So really just coming in, wanting to understand your client is going to go a long way in helping make sure that you put forth the best work product for their case, but then also build a good, strong relationship between the two of you. Corroboration is also really key. So sometimes it's not enough that the person testifies credibly. If there are pieces of evidence that an applicant can reasonably obtain, then we need to get corroborating evidence. So that means that each asylum element either needs to have corroborating evidence, whether that's just testimony or whether that's testimony in some other written document. For each individual element is going to be critical. So we'll talk a little bit more about that. We have a little helpful chart here that kind of gives you a sense of what corroborating with supplemental evidence looks like. So there are country conditions reports. We talked about this a little bit earlier. News articles, reports from NGOs or other credible organizations. Specific ones include Amnesty International, and the UN has great resources available. You also want to get client-specific examples. So that's going to be physical evidence, people who have pictures, police reports, medical records about injuries that they faced, witness affidavits, sometimes drawing a map so that the judge can get a good sense of where certain things happened in a country are really helpful. Past persecution often goes hand in hand with forensic medical evaluation, maybe showing some scars, an x-ray that can show a broken bone. A mental health evaluation is critical. So in the case of Marta, I would probably love to get a mental health evaluation, particularly if she does end up filing past that 1-year filing deadline, to kind of explain the impacts of maybe living in the closet for her whole entire life and how hard that can be on a person. Again, medical reports and pictures can help show injuries, the extent of injuries, and things like that. Future persecution, there are a couple different ways that you can approach this. Again, country conditions are really, really important. We can also provide affidavits from similarly situated individuals. So in the case of Marta, maybe asking her if she's still in contact with people from Colombia and maybe what they've experienced to show that somebody in Marta's same exact or similar situation faces a lot of hardship back in their home country. One thing that's really tough right now is that typically the BIA and a lot of immigration judges uphold the U.S. Department state reports as like the evidence for country conditions. So these are annual reports that the U.S. Department of State publishes every year that kind of review each country's human rights practices and give examples of ways maybe that a country is or isn't respecting these human rights. Since the publication of last year's reports, these reports have intentionally excluded information on specific groups, LGBTQ people, women, people with disabilities, and more. And so these reports, where beforehand they might have been, what we rely on for a lot of evidence, we can't anymore. Luckily for us here in the Seventh Circuit, we have seen the Seventh Circuit repeatedly express skepticism about how reliable these reports are. This is coming from the Department of State. They have to think about like international politics and things like that. So really working to get a wide variety of evidence to help support your case is going to be really helpful. Working with experts is another great way to help support the case. For example, a country conditions expert can help corroborate lack of protections in practice. So this is great when a country such as Colombia has more progressive looking laws on the books, but the lived reality of many people is that they experience a lot of harm. Police don't investigate hate crimes against LGBTQ individuals. This can be really helpful. And they can also help combat these State Department reports that might make it appear that there's no violence against LGBTQ people. Mental health experts can help us explain the effects of trauma on memory. So if you are working with somebody who really struggles to talk about what they've experienced, having a mental health expert talk about why that might be is really great. It can also help corroborate past psychological harm and the ways that they've been impacted by what they've experienced. So here we are, we're back with Marta. I kind of already gave a few spoilers, but what kinds of corroboration would you want to demonstrate that Marta has a future fear of harm based on being a trans woman? We don't have a poll for this one, so you can go ahead and put it in the chat. What kinds of things would you want to look for? For me, I think I'd love to see, oh yes, Kara, country conditions expert, definitely for a country like Colombia, I'd want that. A birth certificate, that could be helpful in demonstrating her sex assigned at birth. pictures, maybe if there are pictures of her dressed up when she was a kid, that would be great. Pictures with maybe friends from the LGBTQ community. Yes, Elliot, witness affidavits. I'd also love if there was like a police report, maybe for yep, Anna, you read my mind. News article about the friend who was murdered, police reports. These are all really great examples of the kinds of things you'd want to do. So once you have the corroborating evidence put together and you also have your evidence, you can really start to craft your legal argument. In immigration court, you are allotted a 25-page brief to set out all your arguments, to cover all 5 of these elements: CAT, withholding of removal, credibility, and maybe other factors if there's like bars in the case. Of course, you can always ask the court for a longer brief, but in practice, it's probably best to keep it short and concise when you can, because immigration judges do not have a lot of time to be reviewing materials ahead of a hearing. It's important to state all relevant protected grounds, make sure that you are building the record for appeal, making all arguments that you think are feasible at the end of the day. Making sure to keep the asylum elements separate, hold yourself to that standard, but most importantly, hold the judges to that standard to make sure that they're not conflating elements and they're looking at each part of the case individually. Be sure to request withholding and CAT protection. In the alternative, there are very few times where you're not requesting CAT protection, so it's important to preserve that. Again, consult the NIJC procedures manual that Jeff put in the chat a little bit ago, and also the immigration court practice manual, which is available on EOIR website, which is going to talk to you about how to put together a brief and things like that. We always recommend that you cite to the Immigration and Nationality Act, the INA, rather than the US Code, and then work to cite to the Board of Immigration Appeals as well as local circuit case law. If you're taking a case with us, that likely means the Seventh Circuit, which is a pretty great circuit to be in the grand scheme of things. When writing the brief, we should be careful to use language that is respectful of our clients in the hopes that it will also encourage the court and DHS to also use respectful terms. So some preferred terms are person with HIV or living with HIV instead of HIV positive, using terms like transgender and LGBTQ. Transsexual and transgendered are not appropriate terms anymore to be using to describe LGBTQ people, and using the term sexual orientation as opposed to something like sexual preference. You might see acronyms such as SOGI, SOGI, about sexual orientation and gender identity, or GNC, gender nonconforming, which can include sometimes TGNC to include transgender and gender nonconforming people. It's important to have conversations with your client, again, about the terms that they use for themselves, why they use those terms, and then prepare them for a possibly hostile court. So in the event, in the case of a trans individual, preparing them that the judge may not use their chosen name or their pronouns when referring to them. They might be sticklers if the birth certificate or identifying documents haven't been updated to reflect the person's actual gender identity. So being prepared for that case as well. Okay, so now we are going to go over presenting the case. I'm going to pass it back to Katie.
Okay, presenting the case. So now we're getting ready to go in front of a judge in the majority of the hypotheticals we're talking about here or for the immigration court. So what does that look like? What do you need now that you have all the evidence, all the things gathered that Tori has talked us through? What are you filing? We already talked about the E-28 extensively. You can file that online, even if it's a paper case, even if it's a very old case, you can file that online to get your representation on file. You should pay close attention to the immigration court practice manual. Unfortunately, they have been updating it more recently, so keep eyes on that too. Don't just look at NIJC's asylum manual. Also, you have to look at the rules of the court. The rules of the court might not specify or will not specify if a judge has certain idiosyncrasies or certain preferences that they want for their court. So reach out to NIJC too to make sure you're getting any of that intel if there are things that this specific judge likes to see or ways that they like to have the filings. In theory, the I-589 is usually already filed, so you are not filing a new I-589. I will flag on the things prior to the merits hearing you're filing would be a notice of amendments to the I-589. If you're reviewing the I-589 with your client and things have changed, maybe they have a new address, maybe they have a new job, super not uncommon, not really a big deal. You would be wanting to provide those, but you also should be reviewing the entire I-589 with your client to make sure the language that was used, the way things are framed, if they had more detail than we wish they had, and it doesn't actually align currently with the way that you're presenting the affidavit, you should be thinking about that while you're drafting the affidavit. You should be thinking about that if you've already started to do some prep with your client that, hey, the answers to these questions now don't exactly perfectly align with what was written or something else has come up and you want to flag it. Flag it for NIJC right away so we can talk with you about how to present maybe that new information or maybe that slightly changed information in the way that is less likely to raise credibility concerns for your client, less likely to raise the question that this is a new claim that could be time barred, which could make the whole application time barred under this case that's called matter of MAF. It's all to say this is quite nuanced and technical, and there is no one size fits all approach. So please reach out to your NIJC point of contact as soon as possible. Have us review any amendments you're planning to file, and please do not file them without first talking to your NIJC point of contact. I cannot stress that enough. Every single thing that's on the prior to the merits hearing list, we would really love to have eyes on it to make sure it's presented in the best way possible, according to all the immigration court practice manual guidelines and with the most current law that is being used. So everything that's being filed, we would love to have eyes on first. That's why you have us as your technical assistants. So please flag anything that you would want to change in the I-589 before filing. You're also going to be filing the brief, the legal brief, which is maximum of 25 pages according to the current practice manual, the client affidavit, and any of that supporting documentation that Tori has already covered with you all. And then if it's everything that you're serving on the court, you have to serve a copy to the government. If it's an online case, meaning an electronic case, that's done by uploading it to the system. But if it's a paper case, you do have to either mail a copy or e-serve ICE a copy of that document, of those documents, all the filings. The format, again, I can't stress enough. Check the current version of the Immigration Court Practice Manual before filing. The default rule right now is that everything filing is due 30 days in advance for a non-detained hearing. As I said, some judges have different rules. Check and see if at the master calendar hearing they gave a different timeline that would control, or if it's a detained case, that timeline is different. And each judge typically has their own timeline for when filings are due. You want to have the annotated index that highlights, literally highlights, the important relevant information. Sometimes the documents themselves are quite large, and so you want to bring the reader's eye to the relevant information so they're not bogged down by usually the quite robust country conditions evidence that you're providing in support of your client's case. As I flagged for paper records, those they can't be electronically submitted. So our tip is to bring that physically yourself or someone on your team, bring that to the court window, get yourself and a copy for yourself stamped. Watch them stamp it at the window to make sure that that is timely filed and going into the record as it should. Electronic case system, you're uploading it. That concludes your service requirement as well. So be thinking through timing for your filing deadline to make sure you know, oh, does this have to be at the window by 4 p.m. or must it be uploaded by midnight of the service area where the court is in order for this to be considered a timely filing? And include a certificate of service. I said you have to serve them. Make sure you're also including a certificate of service on everything you are filing or it will be rejected. I said annotated index. So what does that look like? This is our sample model of what a beautiful annotated index would look like. You have your client's affidavit, you have any supporting evidence that you're providing, you have the proof of your client's identity as much as you have. And then when you're going into the country conditions reports, we prefer that those are organized in a reverse chronological order. So you have the most relevant, most I don't know, disturbing facts about, most pressing, I should say, facts about what's happening in that country right now and why that puts your client's life at risk if they were to return there, from most recent to least recent. And I typically only do 5 years because beyond 5 years sometimes is no longer relevant for your client's case. What does a merits hearing look like? I will note right now that there is a mock merits hearing that you can watch on EOIR website for an asylum merits hearing. If you want to just visualize what it looks like, where's the judge sitting, where is your client, and where are you sitting, and where is the trial attorney sitting? This visual on the right-hand side, this graphic is more or less what it looks like. Typically, your client is sitting beside you rather than going up to the stand to testify. Some judges have different preferences and want the client to be up by them because they're worried a client is looking over your shoulder and reading your notes. Each judge has their own rules, but the interpreter is usually sitting by the judge's side as well. You want to prepare your client, give them this rundown, let them know who's present in the court. Asylum hearings should be closed by default, meaning they are not open to the public. So you, your legal team, the trial attorney, the interpreter, the judge, those should be the only people who are in the room, unless you are also having an expert or someone else testify. But when someone else is added who is not on the witness list, it does make it a public hearing, meaning other people could come in if your client consents to opening it. You want to practice with your client, practice doing both direct and cross exam questions. Prepare for those to be really random, prepare for those to be absurd. Get practice in on objecting to inappropriate questions, irrelevant questions, questions that are misstating the record. You want to do full prep, meaning a full run through of your direct questions. Make sure they make sense to you and to your client, that they are appropriately cueing the information that you want without doing leading questions. You will get objected to if you're doing leading questions on direct. And you want to do a really tough one. Imagine if the judge is taking over and the judge is doing their own direct exam of your client. I've had that happen. So you want to prepare your client for that to be a possibility and make sure your client knows that that doesn't mean that the client, are answering incorrectly or anything wrong. It could just be the judge's style for what they view as the most efficient way to run a courtroom. And unfortunately, they do have some leeway. They cannot act as a prosecutor. They should not be able to act as a prosecutor, Seventh Circuit law says. But they should be an impartial adjudicator, but they can manage the court proceedings. And so in theory, if they're thinking it's going too long, they can interject and ask questions. That's within bounds. So have your client be prepared for that as well. And then when you're getting really close to the date, you want to make sure you're doing something that boosts your client's ego. Make sure they know they have this. This is their story. They are so capable and the best and only person who can compellingly tell their story, and that they're equipped to do so on the hearing. So you're not getting them in their nerves, you're getting them in the best mindset to compellingly tell their story to a court. You want them to understand the asylum elements, again, not using the words like persecution or things that aren't naturally in their vocabulary, but they understand what are the elements of my life that are most relevant for this court, and what are the things that I really want the judge to understand. You want to be having that conversation with your client so it's super clear to them how what information of their story they should focus on, maybe what details are like less relevant and might just cause distraction and confusion. And you really want to prepare your client for all eventualities. This includes, unfortunately, a denial, what happens if it's denied, what is the appeal process, what is the appeal fee. You want them to know all possibilities when they're going into the hearing, so they're not caught off guard and they're fully informed about every part of the process. It is their case, it is their proceedings, and they should know everything that's happening and could happen in their own proceedings. How do you prepare yourself for your merits? Talk to us. As I mentioned, we try to keep track of any sort of specificities we've heard about certain judges, if they like filings a certain way, if they conduct their hearings a certain way, if they're more likely to tell you up front that they want the testimony to be focused on a few things. If they allow an opening, most don't. If they allow a closing, most do. Those types of things we try to track as much as possible, as much as we have information, and we want to set you up for success as much as we can with the information we have. Reach out to opposing counsel. Right now, getting any sort of stipulations from ICE are unlikely. I think we are less likely to get any response from them at all. And if we do get a response, it's almost never agreeing to anything. I don't think that they have no ability for prosecutorial discretion right now, or if they do, it's very limited and not discussed broadly. So just manage expectations for what reaching out to opposing counsel will result in. Review our manual that also has helpful hints for how to prepare yourself, what types of things you want to be bringing to trial so that you're most prepared. Bring your questions. Figure out how the flow of a hearing is, have your closing arguments prepared, be ready to assert your right to give them, even though recently the Board of Immigration Appeals said that that is not a due process violation. As much as possible, you want to have the closing word on your client's case and correct anything that might have been misconstrued or misunderstood by the judge in terms of law or in terms of your client's testimony. Your closing can be quite impactful. If something new comes up sort of in the course of the hearing or the judge seems to fixate on a certain legal aspect that you don't feel is fully covered by your brief, ask to provide a written closing instead of having the closing in that moment to fully address whatever sort of concerns the judge has. And then know that more often than not, a judge wants to provide a decision in the moment, but sometimes a judge will say that they're going to issue a written decision. Oral decisions are typically happening in that moment. Sometimes a judge will set you over for another hearing to provide an oral hearing. If you have an oral decision, you want to take notes about as much as the judge said, because otherwise you will have to get a transcript from the DAR or the digital audio recording, make one for yourself. You won't have a transcript unless you're on the briefing schedule. Usually you won't have a full copy of what that looks like. And the written opinions could take any amount of time to be issued. The reason why you want to pay attention to which one especially is the oral decision is a decision issued that day. The day the oral decision is the day decision rendered, and the day that the written opinion is issued is what's controlling for your appeal window. These are things that you really want to pay attention to. How long do you have to appeal? What is the starting day of your appeal window? So here are your two outcomes. Hooray, asylum is granted. That's so wonderful. If it's live and in the moment and you have DHS there, they can either waive their appeal or they can reserve. If they reserve, that means that the decision wouldn't be final for 30 days if there is no notice of appeal entered by DHS. So it would become a final decision once they waive appeal or once the 30 days have lapsed. Currently, that's the current window. And I am raising that right now because there is some active litigation trying to change what the appeals process looks like. So before your merits hearing, contact us to see what the appeal window process looks like so you're giving your client accurate information and everyone can plan accordingly too. But Right now, 30 days. It's really exciting. It's great. Asylum means that that client is on the pathway to citizenship already. In a year, they can apply for adjustment, and then later they can apply for citizenship. You can get them an I-94, which means that they have proof of their admission to the United States. They have their lawful status, which in and of itself allows them to work. You might want extra documentation of that with work authorization and Social Security without restrictions and other benefits. So contact us so you can get your client on that road to that more stability in the United States, more permanency, which is really exciting. And if your asylum is denied, which may be no reflection of you, likely is no reflection of you, your client, their advocacy, their testimony, more of a reflection of the climate that we are in right now. If it's denied, reserve the right to appeal. And you can have a sort of mixed decision where asylum is denied, but withholding is granted or CAT is granted. If asylum is denied, if part of it is denied, do you want to reserve appeal? And let us know immediately so we can think through what appeal process looks like and make sure that we're timely responding to everything. Taking a case, what are the next steps? I'll pass it over to Charlotte.
Thanks, Katie, and nice to see everyone again. Please bear with us for just the last 15 minutes of our training where we talk about the logistics of, now that you've learned all of this, what you should do if you're ready to take a case. This might be new to some of you, even if you've worked with NIJC in the past, because we've shifted our model in some ways to respond to the current environment. So I encourage you to stay tuned in just for a few more minutes. So as of this past fall, NIJC switched to a time-bound retainer model. And what that means is any new pro bono case we place is under a time-bound retainer. That retainer is for 1 year. So when you take on a case with us, you're saying that within a year, you're going to work up all the elements of the case that we just discussed and any other hurdles that come up along the way. We have our own E28, NIJC does, that remains on file because we're co-counsel on all these cases. And as we mentioned way back at the beginning, we've screened these cases for pro bono assistance. And so we, we know that there's a viable claim and we're supporting you in your representation of that client. Once you enter your pro bono retainer, you're expected to do all the pieces that we talk about and to start working it up immediately. The reason we want you to do that is because the environment is so unpredictable right now. And so we think it is what's best for the client to start working on all these pieces as soon as you get connected to them. That's the affidavit and corroborating evidence we discussed. It's maybe finding an expert and doing country conditions, briefing, monitoring, supporting with work authorization and any other kind of adjacent needs that might come up. And in some cases, it might be filing a motion to set for merits if you take a case that is not yet scheduled for its merits hearing, but that would always be in consultation with your NIJC point of contact. Our expectation is that beyond that year, if the hearing gets set within the next 6 months or really the next full year, we hope you would extend representation. That's because you've built rapport with this client, they know you, they've been working with you, and we hope you'd want to support them at their hearing. If their hearing is not until an additional year, so 2 years after you've initiated your representation, we would expect you to withdraw. This is, again, trying to build in some ability to respond to the really changing environment. We don't want you to be holding this case for years if the hearing gets pushed, but we do want you to be prepared to go to hearing if it happens within that first year or the immediately following year. We recognize this can be a little bit confusing and we are here to support you through it, but the sort of TLDR is when you take a case, you should expect to have it for 1 to 2 years and to work it up and to take it to hearing for any hearing that occurs within that 2-year span. So now I'm going to talk about what makes a successful case team. So we have a wonderful number of people who've attended this training, but maybe there are other folks at your firm who'd also be interested in taking a case, and we'd love to be connected with them as well. We strongly encourage, I'd say close to require, that every case is represented by a team of at least 2 to 3 attorneys, because we know you have a lot of other things on your plate and we want to make sure there's always someone who can support a client with whatever needs arise. Some firms will have bigger case teams and have 1 or 2 people who are the point of contact for the client. We leave that up to you and in your team to determine. At least one attorney, though, needs to be in Illinois or Indiana and obviously prepare to attend the hearing in person with the client and sometimes maybe do some substantive case workup or the practice for the merits hearing in person with the client. We love working with corporate attorneys at corporate partners, but those attorneys must partner with a law firm to take a case, and the law firm would hold the case file. So if you're a corporate attorney and really want to do this, we recommend you go to a law firm that your corporation partners with and ask them to take on a case with you, and then reach out to us, and we'll be happy to help you figure out how to get that set up. You also need your firm's pro bono approval. This is because, as we've discussed and as you can intuit, these cases are resource intensive, not just for the time that they require, but also for the money for an expert witness, for interpreters. And we often try to place our cases with rarer languages with pro bono firms because you all have access to a budget for interpretation that we may not have in-house. So we want to make sure your firm is on board and that they recognize that if you were to for some reason leave your firm during the scope of the retainer, that the firm knows that they're on the hook for restaffing the case. I already mentioned this piece about access to budget, but that's important to think through in advance. Again, we do require our firms pay for interpreters unless you have someone on staff who speaks that language, and expert witnesses are an expectation as well. But the fees piece of it, we love when firms are able to cover fees, but it is not a requirement. I think this goes without saying, but these cases take time and they're bumpy, especially right now. And so we really need people who are willing to weather that course. It is okay if you don't have asylum experience. It is okay if this is the first time you've learned the asylum definition. The most important qualification to have is commitment and dedication to your client. Just in terms of what to expect in roles, we've mentioned this a handful of times now, but we have an NIJC attorney. It could be Katie, it could be Tori, it could be one of our other colleagues who would be your NIJC point of contact, who's providing technical assistance on your case. So we provide training and materials, samples. We have our procedural manual. We have a lot of resources for you. We also are keeping track of policy updates and making sure to distribute those if they may be relevant to your case. And we are reviewing anything before you file it always, because we are co-counsel. What we expect of you, the pro bono team taking on the case, is to watch this training, review our materials, to keep in contact with your client, even in lulls in their case, to prepare the case and all the pieces that we've talked about, and to represent the client before any federal agencies or at any hearings that occur throughout the duration of your retainer. It's really important that you are the client's main point of contact. Once we refer the case to pro bono partners, you are their attorneys, and we want them to be building rapport and going to you. So what are your next steps? Most concretely, you've already watched this training, or maybe some of you are reviewing the video, and you'll also need to review our pro bono guidelines just to make sure you understand kind of what the expectations are when you take a case. Those guidelines will be included in the follow-up email that we send after this training. You'll get pro bono counsel approval, and then you'll email me for a case. We always have an active case list of cases in need of representation. Right now, our case list has 19 LGBTQ asylum seekers in need of pro bono representation. I'm going to include that list in the follow-up email. So you'll take a look at that. You'll review, we have blurbs, and you'll see which of these cases might be a good fit. Factors you could consider would be if you speak a language, if you have some experience with a country where a client may be from, maybe the hearing date seems like it would work well with your schedule, although with the big caveat that hearing dates could change. So we'd ask you to look through that list and then send us a few options that you'd be willing to represent so that we can kind of match make about what client would be a good fit for you. Then our wonderful coordinator, Jenny, who you've met, will send over conflicts for your case. We'll contact the client to let them know their case is being referred. We'll send you the case file, and we'll get you set up and ready to go. So this is what the next steps would look like. Look out for that case list at the end of our training today. We'll send it out tomorrow. But even if right now you're not ready to take a case, but in a few months you are, your step would be to email me, ask for our current case list, and we would go from there. And just to give you a brief glimpse of a few clients for whom we're seeking representation, right now we have a cisgender deaf gay man from Mexico with quite a strong claim and has a master calendar hearing. So that first hearing coming up next January. And we really need pro bono representation for this client because he uses ASL, and there are plenty of ASL interpreters out there, but they're, it's complicated and would be a complicated, but I think really meaningful case for someone to work on. I'm not going to read through each of these. It's just to give you a sampling, but we have many Spanish speakers and also Indigenous language speakers, sometimes speakers of other languages that are all on our case list right now. And in our last few minutes, I'm going to hand it over to my colleague Jenny to close us out.
Thank you, Charlotte, and good to be back. I hope that everyone is feeling excited and is getting a really good sense of the colleagues that will support you on your cases. I'm back, like I promised, way earlier at the beginning with some resources. First will be our website. You can find this recording there. I believe really soon you'll see it on our website as well as our presentation. You'll want to check out the website for manuals. You'll see our pro bono guidelines in there. We encourage you to take a look for other helpful resources that are available or whenever you need a refresher. NIJC will generally also respond to changing immigration policies that inform the work that we do. And so, of course, you can check those responses as well. And you can also, like we've all talked about before, reach out to your supervisor on the case, as well as myself, if you have any questions or would like support with finding other resources. I also wanted to highlight some of the LGBTQ specific resources. So one of the sites that you see on the screen here is for the NIPN. I'm like forgetting the acronym, but I wanted to highlight it because NIJC played a role in putting together a practice advisory, which is considerations in asylum claims for transgender people. This is the National Immigration Project website. I also wanted to take a moment to highlight our LGBTQ Freedom Fund. The Freedom Fund supports incarcerated and detained LGBTQ people by providing funds for bail and for commissary funds, as well as provide the ability for LGBTQ clients to call family members. So these are really invaluable partners of ours, and our hope is that if you support us as a pro bono attorney, or even if you decide that it's not for you, that you will consider donating to this project as well. And of course, we need to make sure that you connect with us on our social media. You can see that we have Instagram, Facebook, LinkedIn. Feel free to connect with us on there. Show your support and consider donating to NIJC if it may be that taking a case is not the right match for you. We always appreciate your support. And then I will pass it back to Charlotte to wrap us up with our CLE information and contact info.
Thanks, Jenny, and thank you everyone for sticking with us till the end. We know 2.5 hours is a long time, and also there's a lot to cover. You are not expected to now be an asylum expert. I hope that it is clear from this training that you would have support throughout the case, but this is enough information in our view to take on a case. So if you have questions, you can reach out to us, but the best thing is once you take a case, you'd have that direct contact with your attorney who's providing technical assistance. To summarize, you will receive an email from us tomorrow. It'll have a lot of information in it. It'll have the slides from today. It'll have a link to the recording from today. It'll have our case list. It'll have a link to our pro bono guidelines, and it will have that survey for CLE credit. I'm emphasizing this one more time because we are not able to extend CLE credit if you don't complete the survey within a week. So when you receive that tomorrow, please make sure, even if you can't take a case right now, that you fill out the CLE survey, you include the 2 words that Tori and Katie provided, and then that you complete it within a week, so by next Friday. So look out for that email, and we're really grateful to all of you for your continued support of this work, and even just for coming to this training to learn more about the work that we do and the challenges that we face. We're really grateful to have a pro bono network that is steadfast in their willingness to step up and support. And if you left today feeling like that could be you taking on a case, we really do hope to hear from you. We have just 2 minutes left, and I think we've done a good job of answering as many questions as we could. So folks are welcome to drop off, but if you have a lingering question, we will stay on for a few minutes to answer them. Please feel free to put it in the Q&A or in the chat. And thank you all so much, and we hope to work with you.